Hey, this is Ben, and we're back to cut another video about long-term disability appeals. I know we've done a bunch others before, but this one is a little different. Again, we're going to tell you things that nobody else is telling you, and I'm a little pissed off. We got another potential client whose claim was denied. She asked the claims rep, what do I do next? And the claims rep said, all you have to do is appeal. And the claimant said, well, what do I do for that? And the claims rep said, all I have to do is send me an email saying you want to appeal. So the email that went back to, and I won't name the company because they all do it, is I, name of claimant, want to appeal the decision on my claim. Please review the attached medical records that are updates and contact me if you have any questions about my case. And that was her appeal. And as you know from watching our other videos, that's not anywhere near good enough. In fact, if an attorney gave this advice to just say, I want to appeal, that would be legal malpractice. So how does the insurance company get away with this? Well, two reasons. Number one, technically the claims manager is correct. All you have to do to appeal is say, I want to appeal. That's like the minimum amount of work to do. It takes your case to the next level. That's the minimum. The second reason they get away with it is that they're not your lawyers. They're on the other team. Their job is to deny claims. And the insurance companies, the disability insurance companies, are hoping that all you do on your appeal is say, I want to appeal. They take the body of records that you've already sent and they give them to the appeals team. You may have some updated medical records, but I tell you that's not going to change their decision. All right? I've never seen a claimant who said, I want to appeal, actually have their claim denial reversed when that's all they did. Here's the problem. And here's what many plans use this exact language, and it's this. In your appeal, you must raise all issues and grounds for appealing a claim denial at every stage of the appeal, or they will be deemed permanently waived. What does that mean? If your appeal is denied and you go into federal court to litigate now against the insurance company, you're not going to be able to add any argument or any evidence to your appeal. Again, this is why they like you to do it, because it adds nothing to the body of work they already have. It's not going to change their decision, and they're hoping you don't find a lawyer. Here's a case we have from a couple of years ago. It's called Hooper. It was a medical benefits case, but it's an ERISA case. The same rules apply. Hooper provided all of his medical records. Then his lawyers in the litigation wanted to add an argument about CPT codes. Fourth Circuit Court of Appeals says, we cannot ignore the fact that Hooper did not make the CPT code argument when the plan could have reached a different internal resolution of his coverage dispute. And even though that might have helped him win his case, we're not going to allow him to make the argument now. Again, in that case, I'm sure United Healthcare, the defendant, was really happy that Hooper didn't do anything substantive in his appeal. Here's a recent, so I'm going to give you a federal court judge recently here in Northern Virginia said exactly this. Now, this is a case that we're handling, and the claimant, same thing. She appealed her claim on her own. In the arguments before the court, of course, now we get involved and we're trying to do everything we can to help the claimant win her case. And Judge Claude Hilton, in an open court hearing and a transcript, said, he said to me, to Mr. Glass, it seems to me that what you're telling me is that it was the duty of Aetna was on the other side, to raise this, again, one of the issues. And if you could go back now, my client could ask better questions of her physicians. And I said, yes, that's exactly what I'm saying. Or she could, and the judge says, Judge Hilton says, or she could get better evidence together. I'm sure that's true. And then he says this, she should have had counsel at the start of the appeal time in order to do her appeal. And I said to him, I'm going to quote you on that, Judge. And he says, that would have been helpful, wouldn't it? And I said, yes, 100%. So here's the point. There's a lot of videos on YouTube about appeals. Make sure that you're not looking at the Social Security appeals. This is different. These are ERISA group long-term disability appeals. I've written a great book on this. Don't try this at home. And if you need more information about getting your appeal done, we're happy to help you. But if all you do is say, I appeal, please review my case, you are going to lose, and you are going to make it much harder for your lawyers to win the case in litigation.